Migration Act 1958. The Migration Act 1958 is an act of the Parliament of Australia that governs immigration to Australia. It set up Australia's universal visa system or entry permits. Its long title is an act relating to the entry into and presence in Australia of aliens, and the departure or deportation from Australia of aliens and certain other persons. The 1958 Act replaced the Immigration Restriction Act 1901, which had formed the basis of the White Australia policy, abolishing the infamous dictation test. As the 1958 Act has been amended a number of times. Deportation decisions provided for in Section 18 the Act are at the absolute discretion of the responsible minister or his delegate. Deportation requires a specific deportation order Section 206 and applies to Australian permanent residents only. Removal is an automatic process applying to persons held in immigration detention and does not require any specific order to be made. Section 198. It covers those persons who do not have a valid visa to be in Australia, whether their valid visa has expired or was cancelled. Legislative history. The original bill was introduced to the House of Representatives on 1 May 1958 by Alec Downer, the Minister for Immigration in the Menzies government. In 1966, the Holt government amended the Act through the Migration Act 1966. The amendments were relatively minor, dealing with decimalization and identity documents for crew members of foreign vessels. Several sources have incorrectly identified the Migration Act 1966 as the vehicle through which the Holt government dismantled the White Australia policy. In fact, the government's actions in that area required no modification of the existing legislation and were accomplished solely through ministerial decree. The Migration Legislation Amendment Act 1989 created a regime of administrative detention of unlawful boat arrivals. Such detention was discretionary. The Migration Reform Act 1992, which came into operation on 1 September 1994, adopted a mandatory detention policy obliging the government. Also, at the same time, the law was changed to permit indefinite detention from the previous limit of 273 days. Mandatory detention has continued to be part of a campaign by successive Australian governments to stop people without a valid visa, typically asylum seekers, entering the country by boat. The policy has been varied since 1992 by the subsequent Howard, Rudd, Gillard, Abbott, and Turnbull governments. 2001, the Pacific Solution. On 27 September 2001, under Prime Minister John Howard, amendments were made to the 1958 Act by the enactment of Migration Legislation Amendment Excision from the Migration Zone Consequential Provisions Act 2001. Specifically, the new amendment allowed offshore entry persons to be taken to declared countries, with Nauru and Papua New Guinea made declared countries under the Act. The implementation of this legislation became known as the Pacific Solution. The policy is regarded as controversial and has been criticized by a number of organizations. The High Court of Australia in Alcata v. Godwin 2004 confirmed, by majority, the constitutionality of indefinite mandatory detention of aliens. 2018-2019 Medevac Bill. The Home Affairs Legislation Amendment Miscellaneous Measures Bill 2018, dubbed the Medevac Bill, introduced amendments to the Migration Act and two other acts in order to give greater weight to medical opinion in allowing the medical evacuation of asylum seekers to Australia from Nauru, previously held in the Nauru Regional Processing Centre and managed. After discussion, the amended bill passed in the House by 75 votes to 74 and passed in the Senate by 36 votes to 34 as the Home Affairs Legislation Amendment Miscellaneous Measures Act 2019. However, the 2018 ruling was overturned in December 2019 after 37 votes to 35 supported the government's move to repeal the law. 2014 Character Tests. In December 2014, after Peter Dutton assumed the position of Minister for Immigration and Border Protection, The Migration Act was amended to impose a character test on visa applicants seeking to enter Australia and foreign non-citizens in Australia. These amendments included the introduction of a new mandatory cancellation provision under Section 513A. Between the 2013-2014 and 2016-2017 financial years, the number of visa cancellations on character grounds increased by 1,500%. According to statistics released by the Department of Home Affairs, the top 10 nationalities that featured in visa cancellations on character grounds in 2017 were New Zealand, the United Kingdom, Vietnam, Sudan, Fiji, Iraq, Tonga, Iran, China, and India. Mandatory detention rules also apply to persons whose visa has been cancelled by the minister, for example on character grounds, allowing such persons to be detained in immigration detention and deported, some after living in Australia for a long period. 2020 Aboriginal Australians cannot be aliens. On 11 February 2020, the High Court of Australia, in a judgment affecting two court cases, Love v Commonwealth of Australia, Foms v Commonwealth of Australia, 2020 HCA 3, first used the tripartite test in Mabo v Queensland, No. 2 1992, to determine aboriginality of the two plaintiffs. The court then determined that if a person is thus deemed to be an Aboriginal Australian, they cannot be regarded as an alien in Australia, even if they hold foreign citizenship. The two men concerned, Daniel Love and Brendan Thomas, could not thus be deported as aliens under the provisions of the Migration Act 1958, after both had earlier been convicted of criminal offences and served time in prison until 2018. The following day, Christian Porter, Attorney General of Australia, said the decision created an entirely new category of people in terms of what the government can and can't do a non-citizen, non-alien, or belonger. Porter said that the government would be looking to deport the small group of Aboriginal non-citizens who have committed serious offences in another way. Human Rights Commission review.